Please note from the offset this judgment was complex both factually and legally. This is just a simplified interpretation of this case to help people get to grips with the bones of it, and its usefulness is therefore relative and subjective. Please therefore read the case in full yourself to obtain a more comprehensive, technical and nuanced understanding of it. This case invoked the subjects of corporation tax and remedies. This case essentially affirmed 6 points of law related to how much damages foreign parent companies with subsidiaries in the UK, or UK parent companies with subsidiaries abroad, were entitled to because of the unfair rollover system HMRC implemented, which financially benefited UK holding companies exclusively with subsidiaries in the UK. This case invoked very large damages, and the test claimants, BAT and FCE, were making arguments to maximise these damages, and HMRC were making arguments to minimise the damages, and both had some points upheld by the court. 2 past cases related to this one, and they have to be known in order to understand the case at hand. The first case, Highly Cable Holding NBV Inland Revenue Comes, 2006, UKHL4, affirmed that HMRC owed some UK holding companies with foreign subsidiaries, and UK subsidiaries of foreign holding companies, damages. HMRC owed these companies damages because HMRC did not allow these companies to implement full rollover relief on their company group losses for corporation tax, but they did allow full rollover relief for UK holding companies with only UK subsidiaries. This system was deemed to be a breach of the law in this case. Secondly, in test claimants in the Franked Investment Income Group Litigation and Orsby Revenue and Customs, 2020, UKSC 47, it was further held that the time bar limit of 6 years backdated from the date of this case against HMRC being raised, applied to the losses sustained because of the rollover system, rather than the 30-odd years the system had been in place and been enforced by HMRC. This second case of course greatly reduced the damages that HMRC would potentially have to pay these UK holding companies with foreign subsidiaries or UK subsidiaries of foreign holding companies for doing this. 6 further issues about the sum HMRC had to pay these companies were decided in this case. 1. The simple rate of interest was to be paid on the sum owed to any company being paid damages. 2. EU law required HMRC to pay these companies damages /restitution. 3. HMRC owed the damages for this and no arguments about enrichment to try and slip out of this were accepted. 4. What foreign parents did in their own tax system, for example writing off losses of these UK subsidiaries, was not of any relevance in deciding the damages to be awarded in the case to the companies. 5. The case on liability is final. HMRC cannot escape having to pay damages. 6. Losses from these companies' foreign parent company, or other foreign companies in their company group, cannot be rolled over in computing the amount which the companies are owed in damages. The test claimants were British American Tobacco and Ford. British American Tobacco essentially set up factories to manufacture cigarettes and sell them. Ford basically set up factories to make cars and garages to sell them, as well as set up financing for the purchase of these cars. In their company groups both of them had companies registered in different countries, rather than just registering all of their companies in the UK, and this meant that due to the rollover relief system HMRC operated for exclusively British holding companies and subsidiaries. Ford and British Tobacco paid extra corporation tax in the UK. Before explaining the facts and legal issues of this case, the nature of a holding company and subsidiary relationship is provided. Please note a holding company and a parent company mean the same thing. A holding company-subsidiary relationship exists where one company holds a majority stake in the shares of another company, i.e. the holding company holds shares of at least 51% in the subsidiary company, meaning that the holding company has the power to appoint and dismiss the directors in this subsidiary company at their annual general meeting, AGM. Holding companies with many subsidiaries are a company group. In addition, it is important to understand one of the ways the holding company and subsidiary company relationship works. Larger companies with excess capital often invest in promising projects proposed to them. These large companies provide the finance for these smaller companies' projects and take at least 51% stake of their shares, thereby becoming the holding company of this now subsidiary. The holding company then appoints the directors in this subsidiary. The subsidiary gets on with the project, and if the subsidiary company makes profits, it typically pays corporation tax before giving the holding company dividends. It is also important to understand the concept of rollover relief /tax credits. This means that if a company makes a £250,000 loss in 2005, and then makes £1 million in profits in 2006, they roll over their £250,000 loss onto the next year's £1 million profits, and only pay the corporation tax rate of 20% on £750,000 of the profits, 1 million profits £250,000 past year losses, rather than on the full £1 million of profits. In other words, 20% of £750,000 profits rather than 20% of 1 million profits is paid by the company, so their corporation tax bill is £150,000 rather than £200,000. It is also important to understand that under the previous UK tax /accounting system company groups, where a holding company was based in the UK and so were all its subsidiaries, the holding company and the subsidiaries in the group could roll their losses over onto each other. This was shown to massively reduce the corporation tax large holding companies had to pay. Some massive holding companies with lots of subsidiaries paid next to no corporation tax for many years in the UK with this system in place. The UK corporation tax rate on paper was 20%, however, for large holding companies it was in reality much lower than this. The key fact of this case was that the HMRC only allowed company groups where the holding company was based in the UK and so were all its subsidiaries to fully roll over losses like this. UK companies with foreign parent companies were not allowed to implement this rollover of losses system, and UK holding companies with foreign subsidiaries could not do this either. This failure to allow all the company groups to roll over losses, and only allow UK companies to do this, was what was deemed to be a breach of the law by HMRC in cases in the past. This rollover system for UK holding companies and their UK subsidiaries was because of UK accounting rules called the Advanced Corporation Tax Act system in the Income and Corporation Tax Act 1988. Section 18, Part 6, Schedule D, Case V, called DV for short, of the 1988 Act was the key section that put this maligned rollover system in place. This was essentially the rule that allowed this loss rollover /tax credit system to take place fully in UK company groups. This UK accounting DV rule, giving full rollover relief only to UK holding companies and UK subsidiaries, meant that UK company groups could fully carry forward losses from previous years in any of their UK companies, and use them to reduce the amount of corporation tax to be paid on the profits of any company in the group, before dividends were paid out. But this could not be done if the parent company was from the EU or the USA, or fully if a UK holding company had foreign subsidiaries. This meant that UK subsidiaries with EU or US holding companies, or UK holding companies with foreign subsidiaries, paid a lot of extra tax to HMRC because of this. HMRC's implementation of this system was deemed to have been a breach of the law. The UK Supreme Court in 2020 had previously stated that the damages caused by this scheme could only apply for the 6-year time bar limit, rather than the full 30+ years that the UK had been operating this system. However, other aspects of how much HMRC had to pay in damages were decided in this case. As stated above, this case was by and large about the technicalities of the damages HMRC owed to these UK subsidiaries with foreign parent/holding companies, or UK holding companies with foreign subsidiaries. In this case there were essentially 7 questions about the amount of damages HMRC owed for implementing this rollover relief system. 1. Can the question of compound interest to be paid on any damages sum be challenged by HMRC, or is it too late as HMRC should have been challenged in previous cases? 2. What rate of interest is to be paid on any sum of damages? 3. What remedy does EU law expect in these circumstances? 4. Has HMRC actually caused any losses to them which can be reclaimed? Can HMRC smuggle out of having to pay damages on a technicality under the law of remedies? 5. Does it matter if the foreign parent company/holding company of the subsidiary was able to write off some of the losses of their UK subsidiary in their own country? 6. Is there any other way that HMRC can argue that what they did was legal? Challenge the case on liability based on new rules they have found. 7. Can losses from any foreign companies related to the UK subsidiaries, such as their foreign parent company, be rolled over for these years to reduce the tax bill the UK would have had to pay? The court held the following 7 points. 1. Yes, HMRC can challenge this point of law. In complex cases like the one and legal arguments which were not thought up previously can be raised at a later. 2. The simple rate of interest and not the higher judicial rate was to be paid on the sums owed to these UK subsidiaries with foreign parent companies. 3. EU law requires HMRC to pay the affected parties damages/restitution for the extra tax they paid. 4. HMRC were deemed to be enriched as a result of this and have to pay damages. The English law arguments about the UK subsidiaries with UK parent companies being undercharged, and UK with EU or other parent companies being charged the correct amount, meaning there was not actually any damage caused, were not accepted. HMRC owe the damages for this. 5. What these subsidiaries' foreign parent companies have done in their own tax system, in terms of writing off some of the subsidiaries' losses against their own profits, is of no relevance in calculating damages. 6. The case on the liability of HMRC is decided and final. HMRC cannot escape having to pay damages on what they owe on the basis of these rules. 7. It is only UK subsidiaries who are able to use rollover relief. Losses made by their foreign parent company or other foreign companies in their group cannot be rolled over to reduce the UK subsidiaries' tax liability.